Jill, we've had a long history of cooperation between the ACCC and the NZCC. What is the framework for that cooperation?
Well, the framework, there's, as you say, a very long history, and it's really supported by a whole framework of both intergovernmental agreements, of statutory provisions, of MOUs between our agencies. We have cross-appointments between our agencies. We have information gateway provisions between our agencies. Indeed, the New Zealand legislation was originally based on the Australian legislation. So we have a very good framework which has been built on through both formal and informal cooperation between our agencies. And this is in relation not just to cartels, but specifically with cartels, because a lot of firms operate across the Tasman, so too do a number of cartels operate across the Tasman. So cooperation, utilising this framework and both formal and informal cooperation is critical to the investigation and prosecution of those cartels. And we have our statutory provisions are similar, though of course Australia has criminal sanctions. New Zealand,
although New Zealand's moving towards that.
That's right. So we don't at the moment, but that we have legislation before Parliament that hopefully will give us criminal sanctions. And we have very similar immunity and leniency programs. We, as mentioned before, we have the provision for information sharing and investigatory assistance that assists us in that cooperation. So you might like to talk about some of the practical ways in which we cooperate specifically in relation to leniency applicants.
Yeah, sure. Before I do that, I just want to emphasise how important the people-to-people connections are between our agencies, because really that's the foundation on which all of this happens.
Yep.
And you can have all the legislative frameworks in the world, but if you don't have the strong people-to-people connections, then it's not really going to work. But there's lots of ways in which we work together in cartel investigations, and they benefit greatly from common immunity applications. So particularly if we've got a waiver from an immunity applicant, that means we can share information with each other. Although I should say we never share evidence except in the most unusual case. It's just not done. We share information and that helps us to coordinate the gathering of evidence that comes to each of our agencies. It helps us to share or helps us to get on with our investigations, because we can discuss investigation strategies with a view to focusing our investigators onto the areas that are most likely to yield results. We discuss case theories. Very importantly, we coordinate interviews and potential witnesses, and we coordinate outcomes as well. Finally, I suppose the important thing to do is to reflect on our experiences, and we do share with each other what went well, what didn't go well. We have quite regular discussions in our monthly calls at a staff level between cartel investigation teams.
And most of that really doesn't rely on any statutory provisions.
No,
it's largely informal, although sometimes we do utilise the statutory provisions, and sometimes providing assistance to the other generates a leniency applicant.
That's true.
But by and large, it's the informal cooperation and that history and relationships between the two agencies that are really critical.
We find there are lots of benefits for us, but also lots of benefits for immunity applicants and other cooperating parties who really get to extract lower costs and the benefits of lower costs associated with us working closer together. So they can bring out a witness to Australia, and we can do parallel interviews with that witness. And we find that in practice is something that applicants really appreciate.
Yeah. And similarly with information requests.
Yes,
you can coordinate those, and instead of answering two slightly different sets of questions, they can answer a combined set of questions.
And that can save parties a lot of money. Information gathering by parties internally can cost enormous amounts of lawyer time, internal staff time, and so if we can reduce that burden a little bit, hopefully it'll make it an easier process for parties to cooperate with us, which is in all of our interests. It's in their interests, in the NZCC's interests, in the ACCC's interests.